All right, good morning. The June
I have
29th,
investment in
2023 School Land Board meeting will come to order. The meeting of the School Land Board is being held in person at 1700 North Congress Avenue in the Stephen F. Austin Building. Access to the meeting by members of the public was published in advance in the Texas Register in accordance with the Texas Open Meetings Act. Any member of the public who wishes to address the School Land Board may do so during the public comment period. The first item on the agenda is approval of the minutes of the May 9th, 2023 School Land Board meeting. Would any board member wish to discuss this item before we take it up for consideration?
A motion to approve.
All right, we have a second?
Second.
All in favor? Say aye.
Aye.
No opposed? All right, hearing no objection, the minutes are approved. Next item in the agenda, item number 2, is the public comment period. Members of the public may address the School Land Board concerning any matter within the authority of the board. As chairwoman, I'm limiting the length of time available to each speaker to 2 minutes. The board secretary will keep track of the time. Do we have anyone in attendance who wishes to address the board on any board matter at this time? All right, seeing none, we will move on to item number 3, which is approval of the consent agenda. For the record, items 3A.3, 3A.12, 3B.6, and 3D.7 were pulled from the consent agenda prior to this meeting. Are there any extractions, members, from the consent agenda? Any item you want to discuss or consider uniquely? Okay. Is there a motion to approve the consent agenda as amended?
So move.
Okay.
Second.
Yes, all right. All in favor, say aye.
Aye.
All right, with no opposition, motion is made and seconded and carries unanimously. Next item on the agenda is item number 4. Consideration and possible action on the scheduling of an online oil and gas lease sale in September of 2023. The chair recognizes Todd Hilliard to present item number 4 to the board.
Hello. Energy Resources staff requests School Land Board approval of the tracts to be offered at a September 2023 oil and gas and other minerals lease sale, along with the terms and conditions for said tracts. EnergyNet.com will perform the lease sale online. Staff requests School Land Board approval of 50 tracts for the lease sale. The attached table summarizes by land type and price those tracts that have been determined to be eligible for the lease sale. Additional tracts are still under review for eligibility, subject to the terms set by the School Land Board. The tracts to be offered for the sale cover approximately 15,000 acres. 35 of the tracts are surveyed school land, and 15 of the tracts are in bays. The bonus per acre will range from $100 to $1,500, and bidding will be on a bonus basis with minimums as stated, $100 to $1,500. That will be dependent upon location and geology. The royalty rate will range from 1/5 to 1/4, either fixed or variable, depending upon location and geology. The variable rate is summarized there below, with production established within the first 24 months. That rate will be 20%. 22.5 between 24 and 48, and 25 after 48 months. The primary terms will range 3 years for upland tracts and 5 years for submerged lands, and the areas will be Laguna Madre, Turtle Bay, Palacios Bay, the Pecos River, and West Texas. And then the table is on page 2 summarizing those tracts.
Members, any questions for Mr. Hilliard?
Motion to approve.
All right, we have a second?
Second.
All right. All in favor, say aye.
Aye.
All right, motion is made, seconded, and carries unanimously to approve item number 4. Thank you, Mr. Hilliard. The next item on the agenda is item number 5, consideration and possible action on the cabin permit criminal background verification policy, and the chair recognizes Tony Williams to present item number 5 to the board.
Thank you. Tony Williams, Coastal Field Operations. Item 5 is a proposed cabin permit criminal background verification policy. Currently, there are 401 cabins on the in Texas Bays. These are, some of them are very close to residential areas. Some of them are quite isolated and could be conducive to criminal activity. To address this, we are recommending a criminal background check for new applicants to the program, similar to what is required for residential leases. The program staff has worked with our legal division to develop a formal criminal background policy. It is structured so that the school land board would approve the policy and staff would perform the background checks. Some of the main points are it would become effective on September 1st, 2023, and require criminal background checks for all new applicants to the program. Checks will be limited to criminal history and will include a review of identified national, state, and county criminal convictions in the last 7 years. 7 years seems to be pretty much an industry standard. Notification of the background check will be in the cabin transfer request form and the cabin permit application. When the permittee has a cabin and they want to transfer it to somebody else, they have to submit the transfer form, and then the new applicant has to submit the application. So both will have notification of the background check. We'll also put it on the website and send emails to the current permit holders. The information, notification of the background check will be sent to the applicants, and the GLO will send the information on the applicant to the third-party vendor, and the third-party vendor will work with the applicant and will provide a report back to staff. Staff will review the criminal background and make a recommendation. Some of the criteria are general extent of criminal activity, recency and age at the time of the crime, relationship of the crime to the ability and capacity to fill the responsibility of a cabin permit, extent to which the permit might offer opportunity to further criminal activity. And some examples of the crimes, but not limited to, would be human trafficking, manufacturing and distributing of controlled substances, property crimes, arson, and some violent offenses. Staff recommends approval, and I'm happy to answer any questions if you have any.
Yeah, thank you, Mr. Williams. I appreciate you and your team's effort on this. I know it was a bit of a process. Members, we have these cabins all off the coast. We had no background check on any of our people leasing them. So if we had apartments, we would do background checks on the people leasing them. So it seems like it was a good idea. Did anyone have any questions?
In the past, have you had criminal activity? Have we ever?
Not that we're aware. There have been criminal activities at the cabins, but typically it has, well, as far as we know, it has not been the permit holders. Somebody's broken in the past and stored marijuana there and stuff, and there has been some questions. So there is some questions about one possibility now, and we're trying to make it a little bit more secure.
Okay.
Was there something that brought this change on? This is new policy, right?
It was a new commissioner. I just came
Okay.
in and I said, what kind of background checks do we do on this? And they said none. And I
Okay.
said, maybe this would be a good idea. So
questions.
it was kind of instigated by
Right. Right.
a dawn of a new era at the General Land Office.
Thank you. Tony, you said this applies only to new applicants. So existing tenants will not go through a background check?
That's the plan. If we need to amend that policy, we can, but our proposal is for the new. And most of the people in the program, 95% of them have been in, their families, and one of the transfers that was on the consent agenda, I've known the gentleman for over 20 years. So we're familiar with most of them, but the new people coming into the program, we want to just make sure we have a little bit of a background check on them.
Thank you.
Other questions?
And the transfer was going from Mr. Self to his daughter, so.
Okay.
And that's the most common occurrence.
I move for approval, Commissioner.
Thank you. Second?
Second.
All right, all in favor say aye.
Aye.
Okay, motion is made, seconded, and carries unanimously. for item number 5. Next item on the agenda is item number 6, consideration and possible action on amendments to the charter of the Investment Advisory Committee of the Texas General Land Office, and the chair recognizes Brian Carter to present item number 6 to the board.
Okay, good morning, everyone. My name is Brian Carter, Asset Enhancement. So the staff is asking that the SOB approve certain amendments to the Investment Advisory Committee Charter, and just for brevity, I'll refer to it as the IEC. So just a little background, there's a lot that's in your memo, but I'll just summarize it very quickly for you. So the IEC was formed by the Chief Investment Officer, who was the head of the Investment Management Division here at the GLO. So that group was primarily, its primary purpose was to invest in private equity vehicles for the benefit of the Permanent School Fund. It invests PSF cash, get returns for the benefit of the PSF. So the IEC was formed to provide an extra layer of vetting before those deals came before the SOB, primarily due to their size and complexity. So in 2016, the staff of the GLO and the GLO leadership decided that it'd be a good idea to have that same level of scrutiny for certain real estate acquisitions and dispositions that would come before the SOB. So subjected some of those deals to go before the IEC before they came to the SOB. So fast forward to January 1, 2023, the Chief Investment Officer and the Investment Management Division are no longer housed within the GLO. Those functions are with the Texas PSF Corporation. However, the GLO still does have the ability to invest in real estate, and so the IEC is still needed to vet those deals going forward. So the charter just reflects the current reality. Now, as you'll see, the red lines in the clean version, the primary changes have been eliminating all references to the Chief Investment Officer, the Investment Management Division, and the private equity portfolio, placing the Senior Deputy Director of Asset Enhancement, that is me, as the chair, instead of the Chief Investment Officer, who's no longer here. Also setting meeting times to be convened as needed in order to give some flexibility to evaluating deals, and out of respect to the IEC members' time. So also one other thing that I'll note is that there were 5 members of the IEC in the past. There are 5 members now. The composition has changed a little bit. The 5 members are myself as chair, Jeff Gordon, who's our general counsel, and 3 members of the public that were selected and vetted by staff and the commissioner. Are there any questions?
Does the new policy change to 4? 4 members, not 5?
Well, no, it says at least 4 members, so
Oh,
we
okay.
have 5 now,
Okay.
yes.
All right. And there's no requirement for outside members. It can be staff as well.
In theory, it could be. However, there is a requirement that the people that will comprise the IEC have some experience in investments or acquisitions or dispositions. So we'd have to meet that standard if they were to be, 4 people within the GLO.
Okay.
But it's always best to have some outside eyes, I think, because the staff here is really good and we're really good at what we do. However, we're not perfect, and so outside practitioners always add some benefit to evaluating our deals.
I noticed on the minutes, at the end of the minutes section, there was added upon request, and perhaps prior to, minutes were always provided. This change here will be, minutes will be provided to the board upon request. Since there's no regular meetings, how will the board know when a meeting has occurred or when they should request copies of the minutes?
Well, the board will know that because when we're going and presenting the deals to the board, we'll say that, oh, this deal went before the IEC.
Okay.
And so the board will know before a deal's gone before the IEC. Now, this will include all deals greater than the threshold is $25 million. So any acquisition or disposition of real estate $25 million or above will go before the IEC. So the board will know that it has gone before the IEC, and it will not come before the board unless it's been passed by the IEC.
Is the 25 million a new standard?
Yes. That's just, we thought that 25 million was a significant enough number to whereas, it would be a large or complex deal that would need some outside vetting.
And I also believe, if I may just say, I think we picked that number too because of the real estate that we've acquired. We haven't really done anything much under that threshold, right?
That's correct.
So we kind of felt like that was the threshold we were talking about anyway, so.
Great.
Real estate keeps getting more expensive.
So staff does suggest approval. Are there any other questions?
Move to approve the policy.
Okay, so
I'll second.
all right. Any further discussion? I know it's kind of a lot. I know, I see people reading. I just want to be sure everyone's had a chance to fully look. Okay, not seeing any. All in favor, say aye.
Aye.
Opposed? All right, the motion carries unanimously. Thank you.
Thank you.
Next item on the agenda is item number 7, consideration of and possible action on request for reduction or waiver of penalty and interest by Pecos River Exploration LLC arising from self-reported underpayment of royalty by a predecessor in Pecos County. And Chair recognizes Ken Mills to present item number 7 to the board.
Good morning, Commissioner, members. I am Ken Mills in the Office of General Counsel in the Oil and Gas section. As the Commissioner said, this is a request by Pecos River Exploration for a waiver of penalty and interest. It's pursuant to authority that the board has under the administrative code, and your memo has the relevant language from that section in the code. In this instance, Pecos River acquired certain assets in February of this year, pretty immediately discovered on an internal review that prior management had not been reporting revenues correctly to the land office. So self-reported, confirmed with staff what the amount of that underpaid royalty was, and then paid it, just under $217,000. When the payment came in, the agency's operating software for revenue reporting saw, oh, this is a late payment of royalty, generated an interest and penalty amount, which are assessed automatically by our system, and sent a bill, and that is the bill that's the portion of this that Pecos River is asking for some relief from. And if you look at the criteria that the board can consider for such a request, in this instance, you have a company that has discovered and self-reported an issue, immediately paid the amount that staff agreed was the underpaid royalty, has fixed the prior misreporting problem that led to this in the first place under prior management. And it might be worth pointing out that it isn't current management that had the use of this money. So in terms of who had the money and ought to be looking at the interest that it would have accrued in the school fund. For all those reasons, staff doesn't want to disincentivize people from self-reporting. If the result of coming to us and saying, oh gosh, we just realized we owe you $217,000, here's a check, and we always said, well, thanks, and here's your penalty and interest bill for another $60,000, that we'll have less self-reporting, and we probably would never have, well, I say we never, but it would have been very difficult to find this with the thousands of leases that are out there and the audit staff where their focus is. So we don't want to discourage people from telling us that they owe us money and paying. So based on all that, staff recommends that the board waive the interest and penalty in their entirety. I'd be happy to answer any questions.
In the past, how have you handled self-reporting?
Well, we tend to look on it favorably. It does generate penalty and interest, and it's really case by case, because if the self-reporting occurred but the company had clearly dragged its heels, or it was one of any number of reporting problems we've had with the same company, and maybe they thought they were about to get caught, so they wrote us a check, there could be any number of factors. And if they had been sitting on the money for 4 years, getting the benefit of interest earned, staff would look at that differently, probably.
So in the past, you sometimes have gone ahead and charged the interest and penalty?
Yes, sir. Yes, sir. And maybe even some of the penalty. It just really depends on the circumstances. And I don't want to overuse this sort of trite phrase, but this seems to almost be the poster child for the reason that this rule exists, because they've really, in our view, they've really done everything right. And the time frames are very short. All this only came up starting in February of this year.
Okay.
Other questions, members, comments? All right, do I hear a motion to approve?
Motion to approve?
All right, second.
Second?
All right, all in favor say aye.
Aye.
Any opposed, nay? Okay, some of y'all were quiet, I was just checking. Motion is made, seconded, and carries by unanimous vote to approve item number 7. The next items, numbers 8, 9, and 10, will be in executive session. The school land board will enter closed session to discuss items number 8, 9, and 10 pursuant to Texas Government Code Section 551.071 for consultation with its attorneys regarding matter involved attorney-client privileged information and legal issues in Texas Government Code Section 551.072 to deliberate on certain matters concerning real property. Following the closed session, the board will reconvene in open session to complete its docket. Visitors should remain here in room 170 as the board members will return following executive session. Thank you. All right, the open session of the June 29, 2023 School Land Board meeting will resume with item number 8, consideration of and possible action on proposed settlement of Canadian River litigation styled Signal Drilling LLC and Jayton Oil Company versus Nutex Operating LLC et al. And the Texas General Land Office and Hutchinson County District Court. The chair recognizes Ken Mills to present item number 8 to the board.
Good morning, Commissioner Board. Ken Mills with the Office of General Counsel. As the Commissioner said, this is a proposed settlement of litigation in Hutchinson County. As I presented to the board earlier, this settlement would leave the Canadian River Mineral Boundary Agreement in place, would leave the agreed riverbed in place, would leave the amended state lease in place, and the school funds 3.5% royalty or non-participating royalty interest, depending on the lease status, in place for the duration of the river boundary agreement, which is for decades to come, for as long as Sanford Dam is there. One aspect of this is that the amended state lease would be assigned to the entities or a relative entity of the plaintiff in this case, and the school fund's share of the compensatory royalty agreement would be assigned to the plaintiff as well for an agreed upon sum. All of this is contingent, of course, on the other side of the litigation signing off on this same deal and all the case being dismissed with prejudice and letting all that settle out, but it would be on these terms. And staff recommends that the board approve the proposed settlement. I'd be happy to answer any questions.
Members, any questions?
Motion to approve?
All right, second. Is there a second?
Second.
All right, all in favor say aye.
Aye.
All right, motion passes unanimously to approve item number 8. Next item on the agenda, item number 9, is consideration of and possible action on proposed mineral production allocation agreement with Navigator Oil and Minerals in Haskell County pursuant to Texas Natural Resources Code, Section 52.154. The chair recognizes Ken Mills to present item number 5 to the board.
Commissioner, members, again, Ken Mills, Oil and Gas Section in the Office of General Counsel. Staff recommends the board's approval of issuance of a mineral production allocation agreement to Navigator Oil on 3 small isolated tracts in Haskell County that are adjacent to a branch of the Brazos River. This lease would be on a 3-year primary term with a 25% royalty and a per acre bonus that staff believes is market for the area. Staff believes that the approval of this agreement will bring under lease and into production for royalties to the school fund tracts that have never seen any prior activity, and that this would all be in the best interest of the school fund. Not something that happens very often, but it's a valuable arrangement where we might otherwise just never see production. Staff recommends approval, and I'd be happy to answer any questions.
Members, any questions?
Move to approve.
Second.
All right, all in favor say aye.
Aye.
All right, Motion passes unanimously to pass item number 10, or, item number 9. Next item on the agenda is item number 10, consideration of and possible action on an application to purchase the surface estate of vacant land, file number SF-16620, McMullen County, Texas. And the chair recognizes Heather Martindale to present item number 10 to the board.
Good morning. Heather Martindale with Asset Management. Item number 10 pertains to the application to purchase 10.11 acres of vacant land in McMullen County. A vacancy is a tract of public school land that has never been surveyed and lies between existing surveys that was previously titled or awarded or sold. They exist because they were overlooked as areas that were surveyed or survey lines do not meet. Vacancies are sold by the GLO pursuant to the terms of Chapter 32, Subchapter D, and Chapter 51, Subchapters B, C, and E of the Texas Natural Resources Code. The sales price is based on the current appraised value. Staff recommends approval of the sale as being in the best interest of the PSF per terms discussed in closed session. Are there any questions?
Members?
I move for approval.
All right.
Second.
Thank you.
All right. Motion is made and seconded. All in favor say aye.
Aye.
All right, motion passes unanimously for item number 10. And, all right, members, that concludes the posted board agenda. Any board member wish to be recognized to provide any further comments or discussion? All right, there being no further business before the School Land Board, the June 29th, 2023 meeting is adjourned. Thank you so much.